Welcome. This will be a practice jury chart. Okay, here we go. There must be a good deal of evidence to present at trial to the jury that the jury can understand. Evidence may exist, but may not be sufficient enough to convince a jury beyond a reasonable doubt. The evidence may also be so complex that it is difficult for the jury to understand. The attorneys must be able to take evidence that is difficult to understand and to present it in such a way that common people can review it and understand it. The evidence must be presented in such a way that the jury understands it. An attorney must not only have sufficient evidence, but evidence that is presented in an understandable format. The attorney must present this evidence in a reasonable manner. The skill of an attorney lies in his ability to present the evidence to the jury in the best way. Often it is not the evidence itself, but the attorney's presentation of the evidence that wins or loses a case. The state may not have much evidence, but the attorney representing the state may be able to make the case. The attorney must be able to understand the difference. The state also must present to the defense attorney any evidence that it may have that would help the defendant's case. If the state has phone records that shows that the defendant was on the phone talking with someone at the time the crime occurred, it must share that evidence with the defense. All right. A little bit of literary practice. Okay, here we go. No one had done that before. Babe became the king of home runs. In that year, something bad happened to baseball. Fans were excited about the World Series. They wanted to find out which team was the best. The Chicago White Sox or the Cincinnati Reds. But some White Sox players cheated. People all across America found out. People were shocked. Many fans stopped going to the ball fields. A boy saw his favorite White Sox player. Say it ain't so, Joe, the boy cried. But it was so. People just didn't trust baseball anymore. Baseball needed someone who could make fans care again. But who was big enough to save baseball? Babe Ruth. That's who. In 1920, something good happened to Babe Ruth. Babe went to play for a new team, the New York Yankees. Babe knew that meant no more pitching, just hitting. Babe met his new teammates in New York City. I'm Babe Ruth. Let's play ball, he said. People wondered, could Babe hit 29 home runs again? I'll hit 50 this year, he promised. Impossible, people said. The season started. Game after game, Babe clubbed home runs. The more Babe hit, the more people paid attention. That Babe Ruth sure can hit, they said. Newspaper boys shouted out the news. Babe hits another. Yankees win. And Babe was right. He hit a lot more than 29 that year. He hit 54. Wow, Babe Ruth really keeps his word, people said. Babe was changing people's minds about baseball, and Babe's home runs changed baseball. Now every team tried to hit more home runs. Other players even tried to copy Babe's swing. That meant more runs and more excitement. Babe loved children, so he did something fun for them. He signed hundreds of baseballs. Right. Continuing story of Babe Ruth. All right, now we'll do a little bit more jury charge practice. Excuse me. Okay, let's see. Here we go. In their opening statements and closing arguments, the lawyers talk to you about the law and the evidence. What the lawyers say is not evidence, but it may help you to understand the law and the evidence. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. You must not consider any statements made by a defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. All right, that will conclude our practice for today.